We are very fortunate and privileged to have with us this morning Attorney Tom Torr. Tom is a New Hampshire native. He's the founder of Cochico Elder Law Associates in Dover, and he was kind enough to accept my invitation to come and spend a little bit of time with us at this forum and talk about some of the basics of estate planning and other elder issues as they interrelate with that. So thank you for joining us, and Tom, the floor is all yours.
Thank you very much. Is this too loud, or I'm not used to having a lavalier? Okay. So, Russ, thank you very much for inviting me today. Things have kind of come full circle for me a little bit, and Russ probably doesn't know this or remember this, but in the early 90s, he got a lot of letters from me. He got one, I guess, about each year from 90 through 93, asking if I could be a summer intern at his law firm in Concord. And I always got a very nice, gracious letter from him saying, thanks, but no thanks, we're all set. But things have kind of come full circle because I met a gentleman taking the bar in 93 in Concord who turned out to be just a great friend. We're actually godparents to each other's children, and he is now the managing partner at your law firm. So, I think that's just kind of interesting, the way things kind of work out. But Russ helped me with a personal case that I had and was really, really helpful. We stayed in touch. He asked me if I would come today. He probably asked me about 6 months ago. And wow, time flies. It's June 1st already. So he asked me if I would come and speak with you today about estate planning basics. And I put together a little PowerPoint that's probably a little bit beyond the basics. But I wanted to make sure that people know exactly what needs to be done at a very basic level in estate planning and give some explanation. Starting out a little bit about my background, I was born and raised in Dover. I was born at the Frisbee in Rochester, but raised in Dover. My parents, the joke in the family is that my parents were both from Rochester. My dad was a farm boy from Rochester. My mom was a nurse. And the joke in the family was that she told him that he would marry him, if he took her away from Rochester. And they went all the way to Dover. She thought she was going to the big city, but it was Dover. So I'm a product of Dover Public Schools, UNH, and I spent about 10 years in DC doing some political work and working at Customs and Treasury back when it was Customs. And I was one of those people that did it the opposite. I was a political appointee and then became a permanent employee, and then 6 months later I left DC and went to law school. And for me, I didn't want to be one of those people going in and out of the Beltway every day, collecting my gold watch at 65, and I felt I had more to give and more to produce. Went to a small school in Ohio at a law school and realized that I needed to be closer to the ocean. Going to Lake Michigan was not going to the shore as far as I was concerned. And Ohio is a wonderful place, but New Hampshire was home. And I've been back ever since and really, really enjoyed it. And, why do I do what I do? I think it's primarily, and no offense to litigators, but, the old saying from, the 70s or so, I'm a lover, not a fighter. I prefer to bring people together. Not that litigators don't, but it's not what I do. It's not who I am at my core. It has its purpose, but I think from what I do is, I say it's all about family, and in the end, that's what it is. That's who we have. The associates, the people that we work with throughout our lifetime, people come in and come out, But at our core, it's our family. And what I want to do is make sure that whether it's your family values, your core values, what's important to you, your legacy, whatever that is. It could be someone with $10,000 in a savings account. Maybe they've got $10 million, $20 million. It's whatever you've built during your lifetime that you want going where you want it to go. Maybe it's to the children. Maybe it's to your church, your synagogue, a charity that's important to you. And to me, making sure that you have that and it passes properly, it goes simply. I tell folks all the time, if you've got a family that works, in my world, that's completely dysfunctional because not all families are like that. But if your family works and everybody's together, I don't want to muck up those relationships. I want to make sure that things flow smoothly and everything goes where it's supposed to go. And again, it's all about family. I think that's really what's critically important for me. So what do? I'm an experienced auto law attorney, licensed in both New Hampshire and Maine, and I specialize in helping individuals and families navigate essential decisions related to estate planning, long-term care, and asset protection. Whether it's drafting wills and trust, guiding families through the Medicaid maze, or ensuring loved ones are legally protected as they age, I approach every case with care and personalized attention. Clients consistently appreciate my ability to simplify complex legal issues and offer peace of mind during life's transitions. And that's the key, peace of mind. So, what are the essential estate planning issues when planning your estate? We want to look at guardianship for minor and disabled children, protecting against long-term care costs for debilitating illnesses, coverages for lifetime disabilities, and the best way that we can pass assets at death. We also want to look at eliminating and lower gift, estate, income, and capital gains taxes. For most of us right now, that's not a particular concern given the high exemption amounts, but that could change at the end of this year. We all may get a new gift on New Year's Day. Let me ask, though, before I go any further, of the folks here today, do we have Maine residents and New Hampshire residents? So we have a couple of Maine folks. So I will try and point out distinctions and differences because there are some differences in the tax code. For instance, Maine has a state estate tax. New Hampshire does not have a state estate tax. However, interesting note, New Hampshire had a legacy and succession tax. It's been gone now for many years, but when we had it, it was 18%, which was one of the highest taxes in the country. But we live in tax-free New Hampshire. So when providing for guardianship for your children who are minors or adults with special needs, when you apply for guardianship, this is going to be for children who are under 18 or who are over 18 and disabled. And here we're allowing someone else to make decisions for them who's going to be responsible after you're gone. If you don't name a guardian, then a family member or someone else is going to have to come forward and step forward and request permission from the court to be able to make those decisions. And in doing so, if you name someone in your will, in your estate plan, there's the presumption that the person that was named is the appropriate person. If you're filing for a guardianship, you're going to file for a petition for guardianship, and I'm going to go over that in a little bit more detail in a moment, talking about if we have a spouse that becomes disabled. If we're providing for asset protection and looking to protect from long-term care costs, in New Hampshire, except for the family home, the non-nursing home spouse, so what I call the community spouse, is entitled to keep 1/2 of their marital assets up to just under $158,000. Distinction here between New Hampshire and Maine. So remember, when we're looking at Medicaid, Medicaid is a joint federal-state program. So you've got federal dollars and you've got state dollars, but it's administered by each individual state. So we've got 50 different programs for Medicaid. So as between Maine and New Hampshire, in New Hampshire, you get to keep 1/2 of the assets up to that figure. So if you get a little over $300,000, the community spouse is entitled to keep that 157 and change. In Maine, you get to keep the first $157,920. Okay. So in New Hampshire, you can only keep 1/2 of the assets up to that figure. In Maine, you get to keep the first 157,900. In Maine. In Maine, so if you have, we'll make my Dover High math a little easy, okay? If we've got $300,000, in New Hampshire, the community spouse is entitled to keep $150,000, 1/2 of the assets, okay? The other $150,000 has to be spent down to qualify. In Maine, let's say we only had $200,000 in assets. The community spouse, the one at home, is going to be able to keep 1/2 the assets up to that figure. So, excuse me, let's say that we had, you're going to be able to keep that full amount, the 157, even if it's less than half, okay, in Maine. A single person, it's now $7,500 in New Hampshire. So here's where, what happens, you've got federal rules and you've got state rules. And every state can have their own rules, so long as they're less restrictive than the federal rules. So for a single individual, the federal rule is $2,000, okay? So if you're applying for, and they get fancy in Massachusetts, they call it Mass Health, but it's Medicaid. If you're applying, a single person applying for Medicaid, Mass Health in Massachusetts, you can only have $2,000 because they follow the federal rule. New Hampshire, it was $2,500. They extended it earlier this year to $7,500. Maine's even more generous. It's the $2,000, but they give you another $8,000, so you can have $10,000 as an individual. Yes?
You lost me when you started talking about the lower amounts after you got away from that.
So,
what is that money for? Is it if you're single or and don't have any?
so Medicaid, as opposed to Medicare, which are oftentimes used synonymously, and they're not, they both sprang from the Great Society. Medicare is a health insurance program for people over 65. Medicaid is an indigency program for older adults. And there are requirements in terms of assets and income, as well as the need to be medically needy. So you've got to qualify medically. For a single person, you can only have assets at that threshold. If for Maine, it's $10,000. For New Hampshire, it's $7,500. Any assets over that figure have to be spent down. I'll be honest with you, the devil's in the details there. There are
What you mean actually by assets, because I've seen different.
assets would be anything that you own. It could be your home, your vehicle, your investments, bank accounts, stocks, bonds. Those are all considered assets. And we look at the fair market value. Planning in this field should be done as early as possible. We like to try, I put it into two different categories. We have pre-planning. as planning that's done 5 years in advance. And then we would have crisis planning. Know that if someone's in a facility, there's still planning that can be done. It's not as effective and efficient, but there's always savings that can be made for folks. But if we do it 5 years, it's a 5-year look back. So if you do an application for Medicaid, the state agency looks at all your financial transactions, all of your accounts within that preceding 60 months.
I think it's important to point out, Tom is talking about if you are at a particular level where you require Medicaid to cover your health. If you have sufficient assets, and so that you have another form of health insurance, it doesn't. A lot of these concerns are not there. Is that correct, Tom?
The dementia care journey, I created this slide because the dementia care journey reminds me of the old game of chutes and ladders that we played as children. There are many different ways to get to the end. We're all going to get to the end. We're all going to win. But how we get there is different for everybody. And if you've met somebody with a diagnosis of dementia, you've met one person with a diagnosis of dementia. It's not the same for everybody. It's different in what you go through. And we've got a bit of a younger crowd, but statistically, for those of us who are over 65, half of us are going to spend some time in a facility. So I'm going to say it's going to be this side of the room, not that side of the room. You know, I used to joke across from my office, there was another attorney, and when I would sit in conference room and talk about that, the 50%, I said, you know, it's going to be, you know, the guy over there in the blue house. It's going to be his clients, but my planning's not quite that good. Yes, sir.
Quick question on that statistic. Spend some time in a facility, meaning end of lifetime, or just at some point you might go into a facility for months and come back out? Those could be two very different scenarios.
Typically, it's end of life or latter stages of life. So we're not just talking about, when we're talking about needing a facility, we're talking about a skilled nursing facility. We may go in for some period, you say I fall, I break my hip, I get it replaced at the hospital, I go to Northeast Rehab, and then maybe to Edgewood or St. Anne's, and make a full recovery and come home. But if I don't make a full recovery, that's home now. And we're in the skilled nursing facility. Preparing for incapacity during your lifetime. So most states now have an advance directive. We used to just call it the healthcare power of attorney. They have an advance directive. So Maine has an advance directive. New Hampshire has an advance directive. It's a state statutory form, okay? When I talk to clients about this, I remind them back when we were in civics classes as children, and they talked about legislation being like making sausage. The advance directive is the sausage. When you've got 140 some odd people in Concord creating a document, this is what you get. When I started practicing in the early 90s, it was much more difficult. Sitting down with a client and reading through the questions and realizing that you had to count the number of times each question said no to realize that no meant yes because of all the double negatives. So when I sit down and review documents at a signing, I always review the advance directive first. Because for most folks, that's the most difficult document dealing with. We're also dealing with our own mortality. So we get that out of the way. By the time we get to the will of the trust, that's easy peasy and really easy to understand in terms of what we're doing there. So it's a confusing document. And what we have to do is we have to take the statutory structure of that document. We can always add things to it, but we can't take anything out. I do add things to my advanced directives. I include questions with regard to dementia and long-term care planning to try and give some structure. Because what you have in the statutory document, it's a black and white document. It's A and B. And there are gray areas there. So we want to make sure that we give as much explanation to folks as we can. So our power of attorney allows you to name who you want to make decisions if you are not able to do so. You need to know that spouses do not automatically have that right. That's a myth. Just by virtue of being married, you don't get to make those decisions. You need to specifically give that power. And without a health care power of attorney, then your loved ones will be forced to seek a guardianship through the courts to get that permission to be able to make decisions. The Living Will Declaration is part 2 of the Advanced Directive. That allows you to refuse life support if you have an injury, disease, or illness that you're not likely to recover from. You're saying, I don't want any extreme measures to prolong my life. If you don't have an advance directive to become appointed a guardian, someone has to hire an attorney, or you could try and do the petition on your own. It's a little onerous and I think confusing. And what I find is it's a stressful time in your life. You want to take care of your loved one, let someone else take care of the court proceedings. They're going to ask the court to be appointed your guardian. So there's 2 questions that are going to be asked by the court. Well, first of all, the judge is going to appoint an attorney for you, and you have your own attorney. My usual joke there is when you have 2 attorneys, what happens? You probably get 3 bills. You're going to have to get doctor's affidavits under oath showing that you're incapacitated. Your attorney's going to interview the potential guardian. And here there's a big issue. Who's the potential guardian? You would think if I'm filing a petition for my wife, Lisa, who's the best one to make health care decisions for him? Lisa. It's probably me. But the court's going to ask 2 questions. 1, does this individual have the functional limitations necessary for the appointment of a guardian? And the court will make that decision. And 2, who is the appropriate person to make those decisions? It may not be my wife, Lisa. She now has to prove herself to the court as being the appropriate person to make those decisions. And then, of course, the court will approve the attorney's fees. And then you've got annual accounting. So you have 2 types of guardianships. You can have a guardianship over the person, the ability to make health care decisions for me, and guardianship over the estate to be able to deal with financial matters. Or you can have both. The guardianship over the person, you have to file an annual report with the court as to the health care needs of the individual during that year. Were there any hospitalizations? Is there any necessity for a change? And over the estate, we're dealing with the financial matters. So within 90 days of the appointment, we're going to file an inventory. I describe it, I show my age now, but I describe it as a snapshot of what the individual had on the date of the appointment. It's like a Polaroid. You take the picture, you wait a minute, you've got a beautiful picture. It's a snapshot of what did that person own on the date that we started the guardianship. And then we have to report annually as to the income and expenses and what's left in the estate. And that has to be done for every year while that person remains under guardianship. The next important item in your estate plan is your durable power of attorney, your financial power of attorney. This allows you to appoint somebody else to make financial decisions for you if you're not able to do so. Without the power of attorney, again, you're going to need to file for a guardianship over your loved ones. And there are a couple of myths about financial issues related to powers of attorney. If you own joint property with your spouse, she can sell the property. That's not true. Someone has to be able to speak for her. The property will pass directly to you, but you don't get to sell it. Again, without the power of attorney, your loved ones are required to file for a guardianship because they don't get to make decisions for you. It allows you, sorry, I've got duplicate slides in here somehow. See, my kids didn't help me put this together. I'm going backwards.
And you just sign a document that you say you grant the power over you, the power of attorney to someone?
The question is about what sort of formalization of the grant of the power of attorney is necessary.
So, Durham power of attorney is signed typically by a notary and 2 witnesses. Could be a justice of peace, but typically it's going to be a notary public, and 2 witnesses. There's also an acknowledgement. Maine has a similar acknowledgement. In New Hampshire, you are the principal, the person making the document, has to sign, basically acknowledging that they realize they're granting broad powers. Some would refer to that power as a power to steal. It's a very, very broad power, okay? So it's very important that the individual that you're appointing is someone trustworthy. They have fiduciary obligations. They have to act in your best interest, good faith and fair dealing. And then there's an acknowledgement for the agent, the person that you're appointing, acknowledging that they realize they are being granted very broad powers so that they understand the strength of those powers.
Another question, I was told by an attorney who's also a Maine state representative that because I was worried that my stuff was written in New Hampshire and then it was the name, he said I've been grandfathered in, but the will is acceptable in Maine as written.
So the question is, if you've executed a document, say in New Hampshire, under New Hampshire law, and then change your residence to Maine, do they continue to be effective?
They should be effective. They should be granted full faith under the Constitution. That said, I would have them reviewed. A couple of issues or concerns that I have. Your will be accepted. You want to make sure that your wishes are still the same as what's in the will. That's really important. With the powers of attorney, they are recognized as well. Again, you want to make sure that you have the correct agent and alternate in place. You want to make sure that your power of attorney does what you want it to do, and I'm about to talk about poorly drafted financial powers of attorney. One thing that I do run into is I had a judge a while back that said, I was at a hearing, he said, Tom, what do you need? I know the banks rule the world. And to a degree they do. But in our powers of attorney, we have language that states that they do not become stale with the passage of time. So that as time goes by, they're still fine, okay? The banks oftentimes, every 5, 10 years, I guess when I started practicing it was 10 years, now I've had them say, well, this is too old. It's 6 years old. The age doesn't matter. It has to be effective. Yes, sir.
For either power of attorney financially or medically, once you grant it to someone, what's the process for determining that those powers come into play?
So the healthcare directive, the healthcare power of attorney, does not become effective until you are deemed incapacitated. So typically, that's going to be by your primary care physician that deems that you're not able to meaningfully participate in healthcare decisions on your behalf. The financial power of attorney, the durable power of attorney, I'm going to give you the old lawyer's answer of it depends. Depends how it's drafted. It could be a springing power of attorney, which means that some event has to take place for it to become effective. So you may, and your attorney typically would draft this, have a letter that's signed by you that says, Attorney Tor, I'm giving you this for safe holding until you hear from my doctor that I'm not capable of meaningfully participate in my financial affairs, and then you're authorized to release the power of attorney to my agent. That would be springing because some event happens and it springs into being. Or it could be effective on the date you sign. Okay? I love and trust my wife. I make her my power of attorney. If I'm off at an estate planning conference somewhere and she needs to get into an account or transfer something, she can do it under the power of attorney. It's durable in that it continues beyond my incapacity. Don't ask my wife if I'm incapacitated. It has to be the doctor. Okay? Some of the things that you want to look for, and this gets to your question with regard to changing states. I think it's a good opportunity to take a look at everything. Maybe you don't need to make changes, but you want to take a look at it and make sure it still meets what you need, everybody's in the right place. If you haven't named a successor, well, this could be a problem. If I name my wife Lisa and Lisa names me, and I became incapacitated, fine, she's handling things on my behalf. But what if she's traveling down the turnpike and involved in an accident and ends up at Wentworth Douglas? And now she's incapacitated. Now, if we don't have alternates, someone's got to step up, and I need a guardianship, and she needs a guardian. So it's always helpful to name a successor, someone that can pick up and handle things if your principal's not, the primary agent's not able. The ability to make gifts is really important, especially when I look at long-term care concerns and whatnot. We want to make sure there's the ability to make gifts. In my world, I want to make sure that the ability to make gifts is not limited by the IRS rules. So, and if you look at most powers of attorney, it's going to say that my agent has the ability to make gifts subject to the annual gift exclusion. So the IRS rule says we can give a gift to anybody. It doesn't have to be family, it can be anybody. Currently up to $19,000. So I can give $19,000 to my church, and my wife can give $19,000, okay? But if we're trying to do some planning to protect assets because someone has a diagnosis of dementia and it's advanced, and we're in a facility, a skilled nursing facility, I don't want to be limited by that $19,000 gift exclusion. We may want to make gifts of significantly more, and we don't want to be limited to that when we're doing that under a power of attorney. Sometimes there's no ability to access retirement plans, IRAs and 401ks. As we get older, they tend to grow. And for many people, it's their principal asset outside of their residence. So we want to make sure that we have the ability to access those. No ability to make a disclaimer. There may be reasons where we want to make a disclaimer and say, no, I don't want this. Don't give it to me in the estate plan. We want to make sure that that's going to be available. And we want to make sure that there's the ability to compensate the fiduciary. If they're working on your behalf and handling all your financial matters, we want to make sure that they can be compensated. It's also a way that we may be able to draw down assets if there's reasonable compensation. And if there's no estate planning powers, we want to make sure that your agent has the ability to handle your estate plan upon your incapacity. We want to make sure it's consistent with what you've done in the past, but there may be things that we want to do, again, especially in a long-term care planning situation. So next we move on to the methods of passing assets at death. And this is where wills and other areas are concerned. So beneficiary designation is one way of passing assets at death. Really easy to do. The assets pass to the person you named. But the problem is you can't be specific and say, I want my shares of IBM to go to my son Michael and my Exxon to go to Christian. You can't designate it there, and you can't be real specific. If you say, I'm going to leave everything to my 3 children, but if God forbid any of them predecease me, I want them to go to my grandchildren. You can't fit that on the little line with regard to your beneficiary designations. You also can't protect your beneficiaries in this case. So if there are lawsuits, creditors, spouses, even themselves, predators, you can't give them any protection because the beneficiary designation, you die, they provide your death certificate, it's distributed to those individuals. So if their spouse files for divorce, it's now an asset to be dealt with in the divorce. Next is operation of law. So here, assets pass automatically. So if you own your home joint with rights of survivorship with your spouse and you die, by operation of law, it passes to your spouse. There's nothing you need to do. Nothing needs to be filed at the Registry of Deeds. I don't want to get down too deep into the I've got some tax information here. I don't want to get down too deep into it, knowing that for most of us right now, and this is a little different between states, because Maine does have a state-to-state tax. New Hampshire does not. So New Hampshire follows the federal level, $13.99 million. That's most of my clients. You know, you can have significant assets if you own real estate in the Seacoast area. You've got life insurance, maybe some retirement accounts. You could be doing very well off, but probably not at that level. What we need to keep in mind, and I've got a slide a little bit later that shows this, is that this is currently the 2017 Act, what's referred to as the Trump tax cuts. Okay, so they doubled the figure. It's been indexed for inflation as 13.99. On December 31st of 2025, if Congress doesn't act, and in these areas, Congress is usually very, very slow. They wait till the last minute. The deadline might even go back and they'll make it retroactive. But on December 31st of this year, if Congress doesn't act, it's going to go back to the prior level, which would be the $5 million, indexed for inflation, about $7 million for an individual and $14 million for a couple. We'll have to wait and see what happens.
All I have is Social Security. I have no, other than small savings account, that's all I have.
Mm-hmm.
And I know the law that there's a law that they let Social Security know the instant you stop drawing grant. What if they're, what's the deal if you haven't spent all of the month's Social Security? Does that go back to them or does that stay with the?
So Social Security, the question is, what happens with Social Security upon your passing? And Social Security is a little bit like renting, and I can never figure it out. Are you paying your rent forward? Are you paying it back? It depends when you pass in the month, Okay, Social Security now is required to be direct deposited into your account. Okay, so depending upon when you pass in the month, you may get to keep your Social Security. If they've paid forward, they're going to take it out the same way. Typically, your funeral home will notify Social Security, and everything is taken care of. My advice would be, don't do anything major with that account for probably 60 to 90 days to allow them time to take it out. I've seen time. The Social Security Administration will pull it. They're going to take it out the same way as they put it in.
Not necessarily.
That's the way it's supposed to work.
My mother died in November, they kept paying her until March, and they sent me a notice to pay them. They did not take it out of her checking account.
And I'm a little concerned, quite frankly, that that's becoming more and more frequent. I've had 2 cases that's happened in 2025. That we've had to, the funeral home and we had to contact Social Security, letting them know, and that they still, it was coming in. So
Notifications before they stop.
keep in mind that if you put your assets in joint name with your children, there's no protection from long-term care costs or their creditors and predators. So if you're applying for Medicaid, the asset's still includable. It doesn't get any protection. If they get divorced or they have an auto accident, you may be living with your stepdaughter. Ex-spouse of a child. Wills. Last will and testament, drafted to transfer your assets at your death. The will, think of it, I look at it like a bridge. We're transferring the assets from me to wherever it's going. And it's relatively simple, typically a couple of pages, depending on how complicated it gets. It's relatively inexpensive. It's easy. You write it and that's it, but it requires probate. And probate is that process of crossing the bridge. Okay? So again, you're filing a petition for administration, the will, and original death certificate with the court. You file it with the court, you get an appointment. It says now that you're authorized to deal with these assets. You gather up the assets. Similar to the guardianship, you're going to file an inventory, that snapshot that I talked about. What's the value? It has to be open for at least 6 months for creditors to make claims against the estate, even if you don't anticipate any, that you're just getting reimbursement checks. You're going to file your last income tax return, and then an accounting and request permission to distribute from the court. One of the things that's a little bit frustrating is in New Hampshire, and Maine, and so many other states, they've gone to electronic filing. So less paper, we're filing everything electronically, either with the county probate court or in Concord. And you would think that that's going to speed the process up. But it's actually been exactly the opposite for us. It seems that everything comes in, and then there's a bit of a bottleneck. So what used to take 9 months to a year is now taking us 15 to 18 months to get done. So it's a slow process. Yes, sir.
Does the trust ensure that you're going to avoid probate?
So a trust by its nature will avoid probate. The key to the trust is it has to be fully funded. You have to align your assets with the trust, which means the ownership needs to be in the name of the trust. Okay? One of the things that's particularly frustrating is most law offices will create a trust, irrevocable or revocable. The property gets into the trust because we do the deed, But then I find people call me after the fact and saying, what do I do with the bank accounts, my Fidelity, my Vanguard accounts, the stock, the bonds? Those need to be transferred in as well. Non-qualified funds. So not the retirement accounts, not the IRA, not the 401k, but the individually owned accounts should also be owned in the name of the trust. Otherwise, they're going to have to go through probate. And for that, so when you do a trust, we do a special type of will. It's called a pour-over will, like a teapot. So think of it as a safety net. It catches anything you die owning in your own name, and that item gets poured over like a teapot into the trust. And it's really a safety net. So if there's a bank account, usually what I see, it's a vehicle. Because somebody went and bought a new car, they were all excited about their new car, and the salesperson doesn't care about how that's titled. We do. We want to make sure it's titled in the name of your trust. They've already sold you a car. They're watching the door for the next couple to come in to sell a car. We want to make sure that that title is in the name of the trust. Otherwise, the pour-over will catches it. We have to go through probate for that vehicle, the bank account, whatever that asset was that got missed. And at the end of the probate, the beneficiary becomes the trust. It pours over into the trust.
Tom, I'm sorry to interrupt, but we've probably got about 5 minutes in terms of people's expectation when we finish up, but please go ahead.
So I'm going to cut you a break. I'm not going to talk about taxes. I had about 3 hours for you. No, not so. Let me go over revocable trusts. So wills go through probate, okay? And oftentimes that's what people are trying to avoid, okay? A revocable trust avoids probate. You wear essentially 3 hats. You're the grantor creating the trust, you're the trustee managing the assets on a day-to-day basis, and you're the principal beneficiary of the trust. By virtue of wearing those 3 hats, you have complete access and control over your revocable trust. Therefore, no protection if you're looking for protection from Medicaid. If we're looking for protection from Medicaid, we're doing our pre-planning 5 years in advance. We're doing an irrevocable trust. Okay? The principal purpose of the revocable trust is probate avoidance and control over the assets. Meaning that the assets, as was asked with the previous question, in the trust avoid probate. Because of that, they are considered countable with an application for Medicaid. Because a trust, the purpose is to avoid probate, assets to be non-countable, so your house would be non-countable in an application for Medicaid as long as you own it individually. If it's in the trust, it's not a probate asset, so they make it countable, okay? They need to be able to get their hand on it after the fact, okay? Your revocable trust protects you from incapacity. You name within the trust a successor trustee that's going to manage assets. So if I create a trust with my wife and we're both the trustees, if I can no longer serve, she serves. Everything continues. If she becomes incapacitated, we have a successor trustee, someone that's named in the trust to manage those assets. They are now managing the assets for her in her incapacity. Again, similar as the power of attorney, fiduciary duties of good faith and fair dealing. They've got to act in her best interest. Upon her demise, we pay the debts and expenses, they get distributed. It can be distributed outright. It can be distributed in what's called a separate share trust, where we apportion it for each one of the children beneficiaries, but we don't give it to them. It stays in trust with co-trustees. Usually the beneficiary child can be a trustee, together with oftentimes the co-trustee of choice, so that we can build in asset protection for the next generation. We also do, in the preparation of the trust, a deed of gift, which transfers all the tangible personal property, crystal, china, jewelry, household effects, into the trust. Think of that document like a broom, and the trust is the dustpan. It sweeps all of those items into the trust. You don't have to go home and go room to room and make a list of all those items. Everything's there. The trust will allow you to make a list as to who you want to receive those items. If you change your mind, I ask clients, please send me that list again, so we know who's in and who's out, so no one's sliding anything in on your deathbed. Usually the kids don't want our stuff. They think it's junk, but if there's something important, you want to make sure it gets to the right person. I'm of the opinion, give it away during your lifetime. You get the joy of giving, they get the joy of receiving, you know it got where it went. But you're not going to take your engagement ring off or a special, necklace or things like that. But if there are things like that that you want to go to a specific individual, we want to make sure that it goes to those individuals. Again, the key, as the question was raised, the key is in the funding, the alignment of the assets, making sure that all those assets are in the trust. And you do it when you start, and you keep doing it. You buy a new car, you buy a cottage, a new house, you sell something. You can do it, you have complete access and control, but we want to do it within the trust. So the keys to your estate plan, we want to make sure that you're planning for incapacity during your lifetime. Your advance directives are going to do that. Your health care, your power of attorney, your advance directive for health. We want to make sure that you've planned for all those contingencies during your lifetime. The what-if clauses. Plan for taxes and the different levels of taxation. You want to make sure that things are flowing smoothly. First and foremost, you want to remember that it's about your family and what you want. Thank you very much.
Thank you so much. Thank you for coming. I'm sure Tom will be here for a few minutes. This is not for individual legal advice, just general information, I always say. But thanks a lot for coming, Tom. It was
Thank you.
very
It's been a
informative.
pleasure.
Thank you.